Welcome to Law and Society. Today I'm going to go over the Supreme Court's oral arguments in Donald Trump's disqualification case. And what I'm going to do first is give you a brief overview, and then I'm going to go into the deep dive. So, for those of you who don't want to spend the next 40 minutes or so going over this, I will briefly talk about what happened at the hearing. So, if you're new to my channel, please like and subscribe, and let's get started. The Supreme Court heard oral arguments in Donald Trump's disqualification case. So, they are reviewing whether to uphold or to overturn Colorado Supreme Court's ruling that Donald Trump is disqualified from being on Colorado's election ballots because he engaged in insurrection and violated Section 3 of the 14th Amendment. And Colorado's courts held a trial, and then the Colorado Supreme Court reviewed it, and the ruling came out. And that's what Supreme Court is considering. And what happened, before I go to the substance of it, first of all, yes, Clarence Thomas did not recuse himself. He was, in fact, the first person to ask questions during an appeal. Also, the way that appellate process works is that each party is given a little bit of time to open their arguments, and about a minute or so, a couple of minutes or so into it, the justices start, peppering them with questions, and the questions don't necessarily go in a sort of chronological manner, in a sense that the topics are discussed uniformly by each of the justices. They can ask whatever they want on whichever issue. They can jump around, and so it's very difficult to follow along with where the justices are going if you haven't read the cases, if you're not familiar with some of the laws that are involved. So uh, Justice Thomas started questioning, and then what the two positions that Donald Trump's attorneys held is that Colorado Supreme Court was wrong because uh, Donald Trump is not an officer of the United States as required by Section 3 of the 14th Amendment. And then there was the Griffin case, which is a precedent, which is not a Supreme Court precedent, which is a lower court precedent, which is not binding on the Supreme Court, but it is old, and it was the basis for which Congress enacted um, a law in 1870, and that law was in the books until 1948. That would have been the only way through which uh, Section 3 of the 14th Amendment could be applied through congressional enforcement. So, that ruling from Griffin is the basis of the second argument that Donald Trump's uh, Donald Trump's attorneys have. On the other side, the argument that the government has, I'm sorry, not the government, the argument that uh, Crew and Colorado voters have, and the state of Colorado, is that the power of the states to control how election procedures are held and how to assess how who is qualified, absent congressional legislation, rests on states and state legislatures and state officers who are in charge of determining, in this case, candidate qualifications. So that power comes from Article 2 of the Constitution and the 12th Amendment, and then the 10th Amendment. The 10th Amendment talking about, unvested powers go to the states, and the 12th Amendment and Article 2 Electors Clause talks about, uh, the power of the states to enact laws to determine who can be on their ballots. So these were the two arguments. Now, a lot of pundits have come out from from the offshoot of just hearing the first oral arguments, and the way that the Supreme Court asks, they're playing devil's advocate in a lot of these questions. They're trying to get as much out of the case and out of these people, and they're also trying to trick them into answering questions that would be to their detriment. And most recent memory would be from the immunity case, and I don't want to talk about the immunity case right now because then I'll get distracted. So now, the way that they questioned each of the parties, the conservative justices seem to be leading Donald Trump's lawyers to conclusions. And, that started out from the very first question, as you'll find out once we do the deep dive. And, the questions that were posed to Colorado electors and crew were very pointed, and they were, even liberal justices Kagan and Jackson especially pressed the crew and citizens of Colorado with questions about the fact that it doesn't say precedent anywhere in the disqualification clause in Section 3. And so it seemed disbalanced, but the way that the conservative justices were more sort of abrasive, and I would go as to say that Justice Gorsuch was condescending to the lawyer of the citizens of Colorado in the way that he, sort of scolded him from the bench because, he was trying to get an answer out of the lawyer, and the lawyer was trying to answer it, but he wasn't, Gorsuch wasn't getting what he wanted to get out of him. So he just sort of, I guess, had a temper tantrum. But other than that, the senior most liberal judge, Sotomayor, she is slow and sort of deliberative in the way that she speaks. And she approached it in a far calmer manner and not in a leading way, so as to let the lawyers speak their cases. Whereas with some of the conservative justices, not Amy Coney Barrett, but definitely Alito and Gorsuch and Thomas, who seem to be leading the question by almost answering the question for Donald's attorneys and then just having the Donald's attorneys say yes or no to that, which seemed to be lopsided in that way. But the questions that were asked substantively, I felt were evenly asked, and nobody other than Gorsuch sticks out in my head. Really were so antagonistic, but the conservative justices seem to give Donald Trump's attorneys more leeway. That has got nothing to do with the substance of the arguments. It's got to do with the general tone of the hearing. So that's why my assessment from this is that there's still a scope where the justices are seeing whether the states have authority under Article 2 and then the 12th Amendment and the 10th Amendment. And on the flip side, the question is whether the justices will hold that Griffin, which is not a Supreme Court precedent, is controlling precedent in determining that only Congress can enforce Section 3 of the 14th Amendment by legislation, which was then, by the way, that is not the law now, because that law was taken off the books in 1948. So the question arises of how enforcement would work if Griffin is not precedent. Would this court have to set a precedent? And I would think that this court would want to set the precedent, whether that be by affirming Griffin or by saying we're going to adopt a whole new test. That depends on this court. So these are the questions that are presented to the court. And the interpretation of officer as applied in Section 3 of the 14th Amendment. Excuse me. So this is the general gist of the arguments that happened at the Supreme Court on Donald Trump's disqualification. I think that the jurists are out on how they will decide. Kagan seems skeptical on the enunciation part of not having president written in Section 3 and why it wasn't. And the argument was that because it says all civil officers under the United States in Section 3 of the 14th Amendment, and that includes. And so the argument against that for Donald's attorneys is that no, officer means appointed officers, not the president of the United States, and that's because of the appointments clause and blah blah blah. So it's evenly matched, and I still don't want to let go of the hope that the justices don't utterly dismiss states' rights and the power under the Constitution of the states to determine state laws on matters which Congress has not legislated. And Congress has not legislated it because whatever law Griffin brought through is no longer law at the moment. And the only other law that is present is, as Justice Kavanaugh brought up several times, is 18 U.S.C. 2383, which is rebellion and insurrection, of which disqualification from office is a part. And what I didn't hear any of Colorado or the state of Colorado or the citizens of Colorado's attorneys argue is that the difference between the incitement rebellion criminal statute and the enforcement and the disqualification clause of the Constitution are separate, because while disqualification is one of the things available, one of the punishments that's required under USC 2383, USC 182383, that's the criminal statute. In the constitutional remedy in the third section of the 14th Amendment, the remedy of 2/3 of Congress removing that disability exists, whereas with the criminal statute, that does not exist. So therefore, that's this distinction between those two, and presumptively the intent of Congress to not have them be the same thing, especially because Section 3 of the 14th Amendment came after 18 U.S.C. 2383. So that this is the general argument. So this evenly distributed, because it is Colorado is asserting the state's right under the Constitution of the United States, under Article 2, Electors Clause, under the 12th Amendment, and under the 10th Amendment. And Donald's attorneys are arguing that a lower level court's ruling that the judge who ruled later reversed course on, alongside with a statute that went along with that case, which is no longer law, is more of a valid argument to not give states their rights. So it's evenly distributed because it's heavily conservative court. What I saw was Chief Justice Roberts, and Justice Amy Coney Barrett asking questions that were more centrist, whereas Alito was relatively quiet. Thomas asked the first questions, setting the tone for how the arguments would be by saying, leading the answer into for Donald's lawyers. And then the liberal justices were quite skeptical of certain parts of Colorado's argument, but they also seemed to understand that the position of the state under Article 2 seemed to not be shakable. Therefore, this is a very difficult case to assess and predict, but I wouldn't put my bottom dollar on saying that the Supreme Court is going to rule in favor of Donald Trump and completely throw out states' rights. I don't think this is the court for that. But obviously, I always take it as anything that I say could be proven wrong and may be wrong. So we will see. So now what I would like to do is take a quick water break, and thank you all for being here. And if you're new to my channel, please like and subscribe. What I'm going to do is go over some of the excerpts that I found to be interesting. And if you are not here for a long time, don't want to stick around for too long, you should probably skip out. If you want to stay for the big bit, here we go. I'm just going to drink a little bit of water and then start it. I have to say that Donald's attorney in this case is far better than his attorney in the immunity case. Or at least the way he argues. Maybe the DC court just was harsher. I don't know. But okay, so at first Donald's attorney started, and Donald's attorney said that he's not an officer. And the second, as I said, was state cannot exclude members and use disability only Congress can. So what Donald's attorneys are saying, in both instances, a state is accelerating the deadline to meet a constitutionally imposed qualification and thereby violating the holding of precedent. And in this situation, a ruling from this court that affirms the decision below would not only violate term limits, which is a case precedent, but take away from the votes potentially millions of Americans. So Justice Thomas opens up by saying asking whether or not Section 3 is self-executing, and saying that, you're arguing that it's not. So what role would the states be, or is it entirely Congress's? And, Donald's attorney says it's entirely Congress under Griffin. So holding of Griffin's case goes beyond even that by saying that a state is not allowed to implement or enforce Section 3 of the 14th Amendment unless and until Congress enacts implementing legislation allowing it to do so. So if this court were to adhere to the holding of Griffin's case, there would not be any role for states in enforcing Section 3 unless Congress were to enact a statute that gave them that authority. Then Chief Justice Roberts. What if somebody came into the Secretary of State's office and said, I took an oath and specified Section 3 and said, I participated in an insurrection and I want to be on the ballot? So the attorney says, no, Secretary of State could not do that consistent with precedent, because then if the candidate is admitted insurrectionist, Section 3 will always allow candidate to run for office, even win elections to office, and then see if Congress lifts the disability after the election. So Donald Trump's attorney is doing sort of this backflip where, nobody has the authority to question Donald Trump being on the ballot until he wins. And then there is the question of if he can hold office. It seems untenable. So, well, then Chief Justice Roberts says, well, then even it's pretty unlikely, or at least would be difficult for an individual to say, I am an insurrectionist, and I had taken an oath. That would require 2/3 vote of Congress, right? So it's saying that, the way for an insurrectionist who has said and admitted all these things to go and then cure the disability placed by Section 3 after getting elected, it would be difficult, which is pretty much in a way asking that Donald Trump has admitted that he's not contending insurrectionist. He's not saying that he didn't participate in it. He and he also wants to be on the ballot. So that means that you're saying under Griffin, nothing can happen until Congress authorizes legislation. So Justice Sotomayor, you want to go a step further and say, so asking a question. You admitted that the concept of self-executing does generally permit states to provide a cause of action for breaches of constitutional provision. Requires implementing legislation to permit the state to disqualify an insurrectionist. That's correct, says Donald's lawyers. Then she asks, you want us to say self-execution doesn't mean what it generally means. You want us now to say it means that Congress must permit states to or require states to stop insurrectionists from taking state office. And then she says, but it's not with respect to how we define self-executing. Then Sotomayor points out that Griffin was not a presidential Supreme Court decision. And it was a circuit court decision by a justice who, when he became a justice, wrote, he assumed that Jefferson Davis would be ineligible to hold any office, particularly the presidency, and treated so essentially talking about Griffin's case and how it came about. But Griffin's case provided the backdrop, here says Donald's attorney, but Griffin's case provided the backdrop against which Congress legislated the Enforcement Act of 1870 when it first provided an enforcement mechanism. Justice Sotomayor, what sense does it say that states can't enforce Section 3 against their own officials? Can states enforce the insurrection clause against their own office holders, or can they enforce it against federal officials, or can they enforce it against the president? These are all three questions in my mind. Donald's attorney, if Griffin's case is the proper enunciation of the law. Then a state cannot do any of those things, Your Honor, suggested unless Congress gives its authority to do so through implementing legislation. So Justice Sotomayor asks, so a non-presidential decision that relies on policy doesn't look at the language, doesn't look at the history, doesn't analyze anything than the disruption that such a suit would bring, you want us to credit as precedential? Donald's attorney, because Congress relied on Griffin's case when it enacted the Enforcement Act of 1870. And then Justice Kagan says, you're not saying that the Constitution gives you this rule. It's kind of the combination of Griffin's case plus the way Congress acted after Griffin's case. And it was later repealed. 1870 Enforcement Act was later repealed. Only enforcement legislation that currently on the books is the Insurrection Criminal Statute of 2383. So that's what the defendant's lawyer says. That's what Donald's lawyer also concedes. He's just better at conceding. So now Justice Kagan asks, so suppose that we took that all the way, suppose that we say there's no Griffin's case and there's no subsequent congressional enactment, what do you do then? So it just is a matter of the first principle without Griffin. It's a much harder argument for us to make. Normally, every other provision of the 14th Amendment has been treated as self-executing. So that right there is another concession. So saying that Griffin is our only case, it's what we have. So I'm going to have a drink of water. Just to say, this is an extremely long, endeavor that I've taken on, and we're going to try and see if I can give you a gist of it from arguments that I thought were important. Let me quickly finish this water. So all of you who are here, thank you for being here. I really appreciate it. If you're new to my channel, like and subscribe. If you have questions about it, do put them in the chat box and I'll get to it when I finish the substantive portion. Or after the video ends, you can leave it in the comment box. That'll be the best way because then I can answer them in a long format. Excuse me. Justice Sotomayor asks, are you setting up so that if some president runs for a third term, that the state can disqualify him from the ballot? Donald's lawyer, of course a state can disqualify him from the ballot because that is a qualification that is categorical. It's not defeasible by Congress. So, Donald's lawyer puts heavy weight on the disability curing section of the 14th Amendment of Section 3 that says that Congress can remove the disability by 2/3 of the vote. So a state is enforcing the Constitution when it says you can't appear on our ballot if you're already served 2 terms as president. So the distinction he's making is that, and he makes his distinction later on as well, any of the other qualifications don't come with the ability of Congress to remove the disability, and therefore this disability should be treated differently. Then Donald's lawyer says, what Colorado has done here, what their Supreme Court has done, under Section 3, President Trump needs to qualify during the time that he would hold office. And Colorado Supreme Court is saying to President Trump, you have to show that you would qualify under Section 3 now, at the time of the election, or at the time that the Supreme Court says. So that's an argument kind of this issue not being right, that it's not the right time, it's not yet the right time to bring it, but the question of when to bring it has to come with a public policy consideration of how much of the court's time and the people's time is wasted on the judicial process if it is not determined when to bring the case. So when it seems most plausible by each of the states who have laws on the books absent congressional legislation, they would bring it at the time that they found it to be right, dependent on the circumstance, dependent on that state. And that's what citizens of Colorado are saying. It's not what I'm saying. I'm making a gist. So now going back to Justice Jackson. But why does the change the initial determination of whether or not you fall into the category? Because we don't know whether President Trump will be excused before he's sworn in, or if he wins the election on January 20th. And a court that is saying that President Trump has to show now, today, that he would qualify under Section 3 is accelerating the deadline, and that the Constitution provides for him to obtain a waiver for Congress. So, Justice Jackson is making it, bringing this out and talking about the ripeness issue. Justice Jackson says, but that's by virtue of hold, right? Hold office. And Donald's attorney says, yes. So it's Donald's attorney, Mr. Mitchell, is looking at it from a very narrow point where this has to happen and that has to happen for Section 3 to apply. And, the president is therefore different than all other officials. And that just goes against the grain of everybody is looked at equally by the rule of law. Now Justice Kagan asks a question. I just want to understand this theory that is sum total of what is the sum total of ways that Section 3 can be enforced? That somebody out there can say, yes, there was a former president who engaged or led or participated in an insurrection and so should be disqualified from office, putting aside the officer requirement. So the answer to that, Donald's attorney, so the answer to that question is going to depend on what your honor thinks of Griffin's case. If this court were to affirm the rationale of Griffin's case, then only way for Section 3 could be enforced is through congressional legislation that creates a remedy. So Congress could reinstate the Election Interference Act of 1870, the quo warranto provisions that they initially had in the 1870 statute. Is that your position, Donald's attorney? Yes, because we believe Griffin's case is correctly decided and should be followed. So he's saying that a case that was decided on the federal level should be followed. Congress should make a law about it, but Congress hasn't. In fact, the law that Congress made was repealed, so it should be, reinstated in order for Donald Trump to be above the law. And then, there's another concession of Mr. Mitchell, who says that Professor Bott and Professor Paulson criticized Griffin's case very sharply because, it talks about only Congress having the power to enforce. So that depends on when Congress enacts. The transcript is long. Justice Jackson. The first is a list of officers that a qualified person is barred from holding. And second, there are specific circumstances that give rise to the disqualification, talking about the first sentence of the disqualification clause. Okay, so are you arguing both in our case or just one? Are you arguing both that the office of the presidency should not be considered one of the barred offices, and that a person who previously took the oath is not subject to disqualification? We're arguing both. It seems to me that then Justice Jackson says, why? It seems to me that you have a list and president is not on it. Then Donald's attorney says, that's certainly an argument in our favor, but there are also, with respect to officer of the United States, that's used repeatedly in the Constitution and the Commissions Clause and the Appointments Clause and also the Impeachment Clause. And every time it appears, it is used in a way that clearly excludes the president. So his argument that, officer, the meaning of officer is different for Section 3. Scrolling along. Oh, now Justice Gorsuch. A lot hinges on the difference in your argument between the term office and officer. And I guess I'm wondering, what theory do you have from an original understanding or a textualist perspective? Donald's attorney. Because it's clear from constitutional text that there are officers that do not hold offices under the United States, for example, Speaker of the House and President pro tempore. These are considered offices of the Constitution, but they're not officers because there's no office. They are officers, but there's no office for them to occupy. They're officers, but they're not offices under the United States because of the incompatibility clause that you can't be on both branches. But we aren't relying necessarily on the thought process of the people who drafted these provisions because they're unknowable. But even if they're knowable, we're not sure we would be relevant in any event because this language, specifically in Section 3, was enacted as a compromise. So, Justice Alito, is there any history of states using Section 3 as a way to bar federal office holders? Not that Donald's attorney is aware, it's because of Griffin. Justice Sotomayor says, I just want to pin down your principal argument on Section 3. You argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States. Your principal argument is that the president is not an officer of the United States, correct? Donald's attorney, yeah. I would say it a little more forcefully than Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he is excluded, the president as an officer of the United States, is stronger of the two textually. Justice Sotomayor, a bit of a gerrymandered rule, isn't it? Designed to benefit only your client? He says no. So you're getting the drift of this conversation. And, it goes on to Donald Trump's attorney saying, there's this gap between the term officer and the phrase officers of the United States, reinforcing the idea that officers of the United States is a term of art that doesn't refer just to federal office holders, which is what the Anderson litigators are claiming, but refers only to those who are appointed, not to those who are elected. So then Justice Kavanaugh asked something about the Griffin's case, saying Section 3 refers to insurrection and raises questions about who decides the process are to be used. That was ratified in 1868. The next year, Justice Chase opined that states do not have the authority, that only Congress has the authority to enforce that. It's a precedent, although not binding. He's just going on about that. And then he talks about right now, the only other statute in the books is incitement, rebellion of 18 U.S.C. 2383. Justice Barrett asked, does President Trump have any kind of due process right here? And they said, Donald's attorney said, we made that argument. We did not make it in our briefs in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments. And so, because they know that there was due process had. So the argument of whether due process was had or not, they don't want to argue it because there was a 5-day trial, and Colorado's attorneys point that out. So now we're going to start talking about the Colorado's attorney coming up. Here, I'll take a quick break and say that, it's 40 minutes already. So, yeah. So I'm going to go into the questions that Justice Thomas asks Colorado's attorneys. Do you have any examples where states disqualified national candidates? And Mr. Murray says that there's one example, and it would seem, then Justice Thomas says, that would suggest that there would at least be a few examples of national candidates being disqualified, and your reading is correct. So the reason why Justice Thomas is asking this question is wondering whether anything like this has ever happened or whether it's unprecedented or not. And the Colorado's attorney is saying, after the Civil War, people felt very strongly, but they did not think that authorizing the South for disqualifying national candidates. That's what Justice Thomas says. And Mr. Murray says, but I think the reason why there weren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. Justice Roberts, the whole point of the 14th Amendment was to restrict state power. On the other hand, it augmented federal power under Section 5. Congress has the power to enforce it. Wouldn't that be the last place that you'd look for authorization of the states? Mr. Murray, no, Your Honor. First, we would locate the state's authority to run presidential elections not in the 14th Amendment, but in Article 2. And that power is merely plenary and determines the means. Certainly, we have reliance on Section 3 insofar as Article 2 gives states this broad power to determine how their electors are selected. And that broad power implies the narrower power to enforce federal constitutional qualifications. So Justice Roberts, are you saying that was implicitly extended to the states under a clause that doesn't address that at all? We would say that nothing in the 14th Amendment takes away from states their broad or merely plenary power to determine the manner of selecting their electors in the manner that they see fit. As this court said in a prior case, that power is merely plenary unless something in the Constitution tells states they cannot do it. And the structure of the 14th Amendment certainly was intended to understand federal power and certainly to restrict state power in some ways, but states are bound to enforce and apply, for example, Section 1 of the 14th Amendment. And so it's hard to see why states wouldn't be similarly bound, or at least less authorized. Justice Kavanaugh. Well, well, when you look at Section 3, the term insurrection jumps out, and the questions are: what does that mean? How do you define it? Who decides? Who decides whether some engaged in it? What processes, as Justice Barrett alluded to, what processes are appropriate? And Justice Chase focused on a year after the 14th Amendment was to say there are different questions, and you look right at Section 5 of the 14th Amendment, as Justice Chase did, that tells you that Congress has the primary role here. Mr. Murray, then the question becomes, does anything in the 14th Amendment say that only Congress creates that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have the power. So then Justice Kagan asks a very pointed question, and it's important to, ask that. Why should a single state decide who gets to be president of the United States? And it's, the effect of that argument is, how can Colorado dictate how other states determine how they would go about their elections? Mr. Murray says, this court is going to decide that question of federal constitutional eligibility and settle the issue for the nation. So, coming to the Supreme Court for the very reason that they're asking this question, why should a single state have that ability? Because Article 2 gives them the power to, Colorado's attorney says. And Justice Barrett says, what if, the hearsay rules are, on and offs, or what if this is just made by statutory of state without much process at all? Mr. Murray, 3 points, Your Honor. The first is that ordinarily, and of course, this court reviews factual findings for clear error, but the president made a point in his reply, the briefs, that sometimes on constitutional questions that require uniform resolution, this court can do more and apply independent review. So you can look at the case by itself. You can look at it to see if it was given due process or not. You can even do your independent review to see if it was given due process. And the state argues that it was given due process, not the state, sorry, Colorado's attorneys, Colorado's electors' attorneys argue that, that's how you do it, is that the states have plenary power to determine under Article 2, and then the federal judiciary takes hold of that and discusses how, just like they are in this case. Let's see here. So there's the idea that, if this happens, that there's going to be floodgates. It's not as important as, as daunting as they would bring it. There's a reason Section 3 has been dormant for 150 years, and it's because we have never seen anything like January 6th since Reconstruction, Colorado's attorney says. It seems to me, Justice Roberts says, you're avoiding the question, which is other states may have different views on what constitutes insurrection. And so, again, the Colorado's lawyer says, just like this court interprets other constitutional provisions, this court can make clear that an insurrection against the Constitution is something extraordinary. It has been, Justice Kavanaugh says, it has been dormant for 155 years. And because of Griffin, and he thinks, Justice Kavanaugh thinks it's dormant because there is settled understanding that even if not right in every detail, was essentially right, and the branches of government have acted under the settled understanding for 155 years. And then he again brings up, the insurrection, rebellion, criminal statute as being the only thing that remains other than Kavanaugh. These arguments, they keep happening, and the justices go back and forth on these portions that let me see. Justice Gorsuch asked, what would compel a lower official to obey an order from that official who has been disqualified if it applies immediately? So there, Colorado's attorney says that there are statutes that require chains of command, and the only way to get someone out of office at that time is through impeachment. Justice Jackson has a problem with the uniformity or lack thereof if states are permitted to enforce Section 3 in presidential elections. So Mr. Murray says, well, certainly if Congress is concerned about uniformity, they can provide for legislation and then can preempt state legislation. But it's not necessary in the absence of federal enforcement legislation. So I want to skip over the rest of this part. The next attorney who comes up is representing the state of Colorado, and that attorney answers questions masterfully and states that the state has plenary authority under Article 2, and they have procedures under the election codes, and that's how they operate should somebody have an insurrection and want to bring that issue up to their Secretary of State, and that's how they would operate. But in this case, Colorado Secretary of State didn't have to go through that process because this case was brought in before Donald Trump could file the papers that the Secretary of State would assess. And it went through the courts, and it was judicially reviewed, and then it didn't need to go through the courts. But other states would have that ability to do that. And while the Supreme Court talks about the chaos that would cause if every state has to go through this, Colorado's Secretary of State's representative thinks that that's part of the system. It's not a bug. That each state go through that process and it be reviewed and it come up to the Supreme Court, and then it be decided in that manner. Because doing it in any other way discounts the state's plenary authority to administer how elections are handled in each of the states. And, there weren't many questions that the Supreme Court had to ask that Ms. Stevenson did not just masterfully answer. And she said, Your Honor, I think we have to have faith in our system that people will follow their election processes appropriately, that they will take realistic views of what insurrection is under the 14th Amendment. Courts will review those decisions. This court may review some of them. But I don't think that this court should take those threats too seriously in its resolution of this case. So that's the long and short of the case. And like I said before, the outcome, don't think that there won't be at least some dicta coming out talking about how Colorado is right. I cannot yet concede that this conservative majority court will completely ignore states' rights, especially since the state argues its plenary authority under Article 2 and the 12th Amendment and the 10th Amendment. So we'll see. I am going to see if I can, come up with some other videos that explains this case a little bit better. But I would like to wait for Supreme Court to quickly rule on this. So with that said, thank you for being here. And I'm going to take off now because my mouth is dry. Please like and subscribe. I'll talk to you soon.